Then we'll do the second question, and Bruno will have the first bite, and then Nick will also jump into this one. This one goes as follows. We have a tenant who continues to pay rent late. The landlord has asked us to instruct the tenant to please ensure that a stop order is put in place. The instruction was given to the tenant, and he advised that he will have this arranged as from the 1st of August 2024. Should the tenant's full rent not reflect on the 1st of August 2024, and he has remedied his LOD issued on the 8th of July 2024, can the landlord instruct us to cancel the tenant's lease? And would there be any penalties for the landlord and tenant's account for cancelling the lease early? So I guess we're dealing with a tenant who obviously has a habit of just paying late, or there's multiple breaches within this a certain period, and maybe also is there an argument for repudiation, obviously because they do state that the tenant did pay late again in March, April, June, and July. Gentlemen?
Sure. We get the question very often when a tenant continues to pay rent, but never does so on time. And a lot of people would typically look at this and ask, well, is this really the biggest problem that you have? Bearing in mind that the tenant is actually paying, it might not be as grave a situation as you think it is. Unfortunately, what we don't always think about is the fact that landlords, more often than not, have some form of debit order that goes off their accounts in order to cover mortgage bonds. They've got liabilities towards the municipalities to pay rates, taxes, water, electricity, levies to body corporates and the like. And so the landlords do have these obligations. So I think tenants need to be sensitive to this and need to realize that paying on time will ultimately impact them, because if the landlord stops paying the municipality and, for example, the power gets disconnected because the rates weren't paid, then it does impact the tenant. So that's just something to consider as a public notice, as it were. Tenants need to be mindful that they're paying the landlord, but for a very specific reason, and often it's not simply just for profit. So serial defaulters, which is how we refer to them, are any sort of debtor, in fact. But when it comes to lease agreements, it's a tenant who continuously thinks, and this is also another myth that we find happens very often, is there's a 7-day grace period. There is no 7-day grace period. There were contracts in the past that did mention that a person would have within 7 days of a fixed date in order to pay the rent. But the reality is the contract says pay it on the 1st, pay it on the 1st. So if you fail to pay it on the 1st, you are in breach of the agreement, and the agreement may be cancelled. But this is where we have to qualify this answer across the board. If the Consumer Protection Act applies, you have to deal with it very differently. And I think Nick will touch on that. Nick will also touch on that when he gets his bite of the cherry when it comes to this question. If the CPA doesn't apply, different circumstances. For example, our firm tries to rely on the argument of repudiation. Now, what is a repudiation? It is, in theory, a breach of an agreement and is dealt with the same. But the difference between a repudiation and a normal breach is that a repudiation is an understanding that the person that has an obligation in terms of a lease agreement no longer wants to be bound by the agreement in terms of which they have an obligation. And this arises very often when people want to abandon contracts, or they simply have no intention to be held liable. So trying to give them notice that they need to remedy any form of breach is meaningless, because there's no intention at all to perform in terms of those contracts. And through a repudiation, a landlord may be entitled to accept the repudiation. That's in terms of legal terminology, one accepts the repudiation and releases the tenant or the contracting party from the agreement. But with this comes the consequences, obviously, of there being damages that arise or whatever the case is. And the tenant, on the other hand, would have to return the property because now the lease has been cancelled. Now, we don't see this argument very often because the CPA is so strict on the time frames and the 20 business days notice, and the fact that it seems like a meaningless fight to have if the person is at least still paying the rent, is just paying it a couple of days late. So to have this fight and to go to court and ask the court for determination on whether this position in law is acceptable has been increasingly difficult because you cannot find the perfect cases in order to do this. But it is definitely an approach. And at the end of the day, also as a landlord, you want to try make this a threat or make this a scare where the tenant understands the consequences of actually paying late. So sending out a notice like this, sending out a letter threatening that this is what you're going to do if they fail to remedy the lease agreement might render the results that you're looking for. So now, Nick, from your side, maybe I don't know if you want to have a discussion of the CPA versus non-CPA lease agreements and how to deal with serial defaulters in those instances.
Yeah, so the method that you use, funny enough, we've used as well. So letter saying to them, look, you're habitually not paying in time, and we're going to deem that conduct to be a repudiation of the lease agreement and cancel as a result of that. It's a method that can be used. Just some other things I want to touch on. I touch on the CPA as well. So if we deal with circumstances where the CPA doesn't apply, okay, there are a lot of lease agreements out in the industry that also deal with circumstances like this. So there are, if you look at your lease agreements, there are certain clauses that say if you have a similar breach within a 12-month period, okay, this is something that's very, very reliable for cancellation for habitually late payers. For your commercial contracts, I know the bigger property managers have those clauses as standard. So if there is a consistent breach of the same kind, so they don't pay rent over and over and over, that would trigger an ability for the landlord to cancel in the circumstances. Absolutely successful. The other thing is, so when we're talking about the CPA, obviously we're concerned with Section 14 of the CPA. Fixed term agreements. Okay. So what's important to know is the minute you're not dealing with a fixed term agreement, Section 14 is not going to apply in the circumstances, and you're not going to have the requirement to do a 20 business day notice. So the difficulty with the CPA is if you have a habitually late payer, what the law expects of you is to do your notice, your letter of demand, giving them 20 business days notice to remedy the breach. Now, habitually late payers, obviously, what's going to happen is they're going to pay within that 20 business day period. Okay. And so you won't have the ability to cancel because they've now remedied the breach. And by the time the next month rolls around, now you've got to do another letter. Unfortunately, the intention of the CPA is to provide that period for a consumer of a product so that they've got a bit of breathing room. So if you're in a fixed term agreement, there's very little you can do apart from just issuing these letters. Like we mentioned earlier, you can have an argument about repudiation of the agreement and go that sort of direction depending on how bad these tenants are. The other clause I want people to look out for within lease agreements, which also can help in the circumstances, is certain lease agreements in the breach clause allow the landlord to change a lease agreement to one that is running on a month-to-month basis in the case of a breach. Also a very helpful term in the case of a breach of a lease agreement, because in those circumstances, what a landlord can do is they can say, okay, I'm no longer dealing with you on a fixed term basis. We're going to do this on a month-to-month basis, and you change it to a month-to-month agreement. Also perfectly valid, depending on the terms of your lease. And then you now are in a position where you no longer have to consider Section 14 because you're no longer in a circumstance that you're dealing with a fixed term agreement, which means you won't have to give a 20 business days notice as required by the Act. You can follow the terms of the lease itself, or you've also got yourself the ability to just terminate the agreement on a month's notice at that point. So there are a couple little clauses that have been snuck into your lease agreements. If you have a decent lease, have a look for these clauses. They can be very helpful. Alternatively, what Bruno mentioned, setting yourself up in a position where you're saying to the tenant, look, you're clearly not intending to actually uphold this agreement, and you set yourself up for a point where you accept the repudiation by the tenants in the circumstances, is a method you can use.
Yeah. So thank you very much, then, Nick, and both to you, Bruno. So we've got the